Well, good morning, everyone, and I hope you had a great beginning of the year. Today we have an incredible speaker for a very interesting topic, which is what is going on in competition law enforcement in the EU. For that, we have the privilege to have Olivier Guersent, who you all know, who is the Director General for Competition at the European Commission. So, without further introduction, Olivier, the floor is yours.
Muchas gracias, Julian, and buenos días a todos. Let me continue in English. You're better off, I can assure you. Okay, well, I'd like to run through a number of relevant trends in competition law in the EU at the moment. And I'd like to address successfully the DMA, very topical. As you know, the DMA goes live on the 7th of March, so it's really in a few days. What we are currently doing with respect to abuses of dominant position with the review of Article 102 guidelines. We're also reviewing our main antitrust regulation, Reg 1, so maybe a bit of a flavor of what you should expect there. And finally, a system that has been very topical in recent cases in the EU, and that I think is interesting for everybody around the world, which is the ecosystem series of harm in merger control. You may know that we have recently got a first case of entrenchment in a booking case that we prohibited. So, and then of course, I expect this will last about 30 minutes, and I'm happy to dedicate the next 30 minutes to answer any question you may have. So let's start with the DMA. If you take a step back, I mean, I joined back DG Competition from Financial Regulation a bit more than 4 years ago. And in December 2020, so a bit more than 3 years ago, not many would have thought that something like the DMA would come into existence and will come live already now in just a few days, as I just said. And certainly not in that very short time frame. So in 2 weeks from now, on 7 March morning, designated gatekeepers will need to comply with their obligations. And you will have already seen the first announcement of measures that a number of companies have undertaken or will undertake in order to ensure compliance. Meta has announced some, Apple has announced a bunch of measures we're currently assessing, Microsoft, etc. The effect of the DMA is obviously not limited to the EU. We don't want to toy with extraterritoriality. We are enforcing the DMA in Europe and not beyond, but you can see some Brussels effect already, and that the DMA has encouraged other jurisdictions to think seriously about similar solutions to curtail power of incumbents. And you see also that some of the incumbents do not want to have different business models in different regions of the world, so they will implement DMA compatibility measures across the board for their entire operations. Of course, I don't mean to say DMA is perfect and will solve all the problems in digital under the sun. It will not. Digital is a very fast-evolving set of markets, and there are always new cutting-edge technologies, new developments. If you think only of cloud and AI, they're currently not captured by the DMA. There will have to be, and it will be a challenge, of course, to adapt the DMA in order to make it work for AI and cloud. And indeed, this is what we're doing. We're keeping a very close eye on, in particular, these two parts of the digital ecosystems. And we have, as you may know, launched just a few weeks ago a very big exercise in order to better understand how AI works, what it means reality in terms of antitrust or DMA enforcement. So this is certainly something we'll have to follow. But you should already see a number of changes on the ground on 7 March morning, like the possibility, for example, to download apps outside of your app stores. Now, let me move to abuses of dominant position and the work we have currently undertaken under Article 102 of the treaty. That's a very important project we have. Almost a year ago, on 27 March 2023, we have announced the launch of an initiative in order to adopt guidelines on exclusionary abuses of dominance. This is a very important policy initiative. The current guidelines on unilateral conduct date back 2008. And actually, I was already at the origin of these ones. At the time, I was in the private office of Commissioner Cruz. And the 2008 guidelines are very unusual guidelines for the European Commission because they are declaratory. You know, unlike in the US and maybe in some of your jurisdictions, because of our continental law system, all guidelines tend to wrap up our experience in terms of enforcement, as well as the case law of the court, in order to give some light onto what you should expect in the future. So they are fundamentally of a different nature than US guidelines, for example, which are meant to signal to judges the changes that the administration would like to see. Actually, the 2008 guidelines were a bit American in the sense that we didn't have any enforcement track record in terms of bringing more economic analysis into unilateral conduct. But we wanted to signal to the judges and to the market that we wanted to move to a test of at least potential effect of the practice from a very legal test that was prevailing before. So now we are 15 years later, 30 court cases, about 25 commission decisions. So it's time to see how what was announced in the guidelines was implemented, not implemented, modified by the courts, wrap up, and give a new perspective for the future. And this is what this new set of guidelines is about. It is about providing further transparency and how our own enforcement practice has developed and is likely to develop in the future. That is really what it is about. So we have launched a call for evidence when we've been launching the initiative, and stakeholders have been answering very favorably in terms that they see really a clear benefit in having guidelines on the enforcement of Article 102 and exclusionary abuses. And there is also a clear call for legal certainty, at least as much as possible, going forward. And this is exactly what we want to achieve with these guidelines. We expect them to have a positive impact in providing greater clarity on the role of the well-established effect-based approach in the application of Article 102. So our experience in terms of enforcement of the case law of the Union courts have been mostly on exclusionary abuses, and that is why we will focus the new guidelines on exclusionary abuses. We have 3 main objectives in the run-up for these guidelines. First, we want to explain the relevance of a number of crucial concepts like the notion of competition on the merits, or what means being capable of exclusionary effects in the words of the courts. We want these guidelines to be pragmatic. We want them to offer really practical guidance for practitioners. And for that reason, we will articulate the framework of analysis for specific abuses like margin squeeze, tying, refusal to supply, as they were developed by our courts. And finally, these guidelines are meant to codify how the effect-based approach has been implemented in the Union, and is not meant to depart in any way from an effect-based approach that I would like to make very, very clear. So the current plan is to publish the draft guidelines in the middle of 2024, so not far from now. gather the comments, and our perspective is to adopt the final text somewhere in the course of 2025. So that's how we see it. So you should expect in just a few months to have a first draft for your comments, and your comments would be extremely welcome. Let me now move to another very crucial policy project, and this is our evaluation of our main antitrust regulation, Regulation 1/2003. This regulation has served us very well, but it's 20 years old, so it needs a review and maybe a revision. For those that are old like me, you may remember that before 2003, the EU antitrust was working in a completely different setting, working on the basis of notifications, and we have moved from notifications to a system of direct enforcement with the system. So we do not accept notifications anymore since the 1st of May 2004. So Regulation 1/2003 has really profoundly changed and modernized the procedural framework of antitrust enforcement in Europe. It abolished the notification system. It established the parallel application of EU competition rule by both the Commission and the partner authorities of our member states within the European competition network. And it meant for the Commission abandoning its monopoly of application of antitrust rules in the EU. So it was an historic and even revolutionary reform at the time. The call for evidence we launched revealed that an overwhelming majority of member states see that as being quite widely a success. But there is a genuine question. So is this regulation that is widely a regulation of the last century? Because I remember I was one of the pioneers that did that work. So we started the work in 1997 for the regulation to be enforced in 2004. And the world was very different back in the days. So we need to really review crucially what is still fit for purpose and what is not. So at the moment, we're finalizing the evidence gathering process for the evaluation. We have gathered evidence from a large number of sources throughout the EU. We have launched a public consultation, which was running between June and October 2022. We have organized a conference in June 23 for a first stock taking, and a workshop on specific topics of specific interest in October last year. Now we are finalizing the evaluation support study, which we will publish, and the outcome of this study will feed into the evaluation process. Now, at this stage, it's too early. There is no conclusion that the regulation needs to be revised, and even less how it needs to be revised. We will sketch out our first ideas in a staff working document that we will publish around the summer 2024 in order to explain what has performed less well, and where we may consider revising. But whether or not there will be a proposal to revise the regulation, that is something that will have to be decided later on by the Commission itself, meaning the College of the Commissioners. So it's clearly too soon to reach conclusions, and these issues are quite complex, frankly. But let me maybe take a moment to share with you some preliminary thoughts on what are the possible problems we see with the procedures, and what are some of the possible solutions. The first remark is very obvious, is that this regulation, as I said, was imagined in the last century, and it's very clear that it was drafted for a paper world investigation, not for a digital world. And of course, the challenges we are facing in a paper-based world is completely different than the challenges we're facing now, where everything is digitalized. So that will, in my view, request a number of changes in the regulation. The functioning of our antitrust enforcement system is premised upon the Commission's ability to effectively detect infringement. And so we must make sure that our ability to do so remains intact today and in the future. So that means the digital transformation requires, in my view, an investigative toolbox that is fully in line with our needs to detect and investigate infringements in the digital age. And it is, in my view, quite clear that the rules of 2003 do not meet that requirement. So there are some areas where adjusted procedures, in my view, should be done, and with a view to increase our efficiency. Let me take an example. It's a bit abstract what I make. So about powers, for example, allowing the Commission to impose a legal hold, so a freeze of information on companies' servers. For the time being, we cannot do that. And because we cannot do that, it's very inconvenient for the companies because we have to seal the hard drives for a very long time. Well, if you could freeze the information, that would be a lot more convenient for the companies and also a lot more flexible for us. Think about the powers to conduct remote inspections. I mean, when the information is located on a server that is not located in the premises of the company, why should you be in the premises of the company to inspect them? It would be more convenient for everybody and less disruptive for the companies that we can conduct remote inspections. And also more effective for us. No need for our officials to travel to the premises of the company. They can do it from the offices. We all teleworking. I mean, today I'm at home, Julian, you're at home, many of you are at home, and we're working on a very regular basis from our home offices. So we need to clarify our powers in inspecting private premises, private devices in this era of widespread teleworking. And none of this is very clear in the current set of rules. Also, the ever-increasing amount of data in existence leads to ever-increasing file size. So this makes the treatment of the files and the granting access to it for defendants sometimes extremely complex. We may need to think about ways to fix that. One is to think how in the digital age we can better find a balance between effectiveness, efficiency, and respect of course, of the fundamental rights of the parties. We have thought about that already, and we have provided for a solution in the Digital Market Act, because in the Digital Market Act, we have put in place a system that allows access to files under what we call terms of disclosures, which you may also know as confidentiality rings. We will see how it works in the DMA. If it works well, my view is that we should generalize this across the board in antitrust enforcement and make it one of the points on which we may wish to revise Regulation 1. What that means is that those of you that are external advisors, so practicing lawyers, would have access to the entire confidential file. So no need to clean for confidentiality. And you would set among lawyers bound by the legal privilege and the rules of the profession, what is confidential should not be transmitted to the clients. That, in my view, is a quite effective way to solve it and will gain a lot of time and pain to everybody. We should think whether we do not have an interest to put such a system in place, for example, for cartel procedures, where the handling of confidentiality is something that takes months in the current system. And such a system would probably allow to make huge gains in time in the procedure. A second area in which I think we should give careful consideration are interim measures. Interim measures in the European systems are used very, very seldomly. We have taken the first interim measure case for 20 years in 2019 in Broadcom, and yet it is very, very effective in terms of speeding up cases and making enforcement more effective. So I think we need to think about we can achieve a better balance and make more often use of interim measures. And maybe last, but certainly not least, complaints. In our system, complainants have a formal right to complain. And that means that they also have a formal right, if we want to reject a complaint, to get this rejection done by means of a formal decision that is challengeable in court. I dedicate a considerable part of my resources to this. And frankly, it may be occasionally that we reject a complaint that we shouldn't have, but I can tell you most of the complaints we reject are ludicrous. But some of these complainants are very, very persistent. So I don't think it's the best use I can make of my resources to reject the complaints of a judoka from the Belgian Federation against the Belgian Federation of Judo because she was not selected for the Olympics, and she complains that this is an abuse of dominant position. Yet, I have to reject this complaint by formal decision. And if this judoka wants to bring me to court, she can. Actually, it's a real life example. She did. And I have to defend the court in case for 2 years. I don't want to have to do this anymore. So I think we should seriously think about changing the system for complaints, not granting an actual right for a fully fledged decision to reject the complaint. Let me finish with merger control and ecosystems series of harm, because that's, I think, is one of the most interesting recent development in our merger control enforcement. Ecosystem theory of harm is kind of a catchy phrase, but it's important to unpack what it means really. And in reality, for me, it is a continuation of what we've been doing in the past. So there's no real correction in the course of action in merger control per se, but rather an adaptation to the realities of the digital world. So ecosystems, what does that mean? Well, let's say that means a business organization reality in today's economy. I mean, that means that in some digital markets, notably, you need to consider a set of related markets and a set of related services in these various markets and their interactions. And the relationship are not necessarily vertical, not necessarily horizontal. So it kind of breaks the boundary of the way we think traditionally in antitrust. To do our job properly, I think we have to be in tune with these market developments and realities and take them into account. So that's why we need to be able to grasp what this ecosystem dynamics mean in terms of market forces and how it drives market developments. And therefore, what is the potential for detrimental harm to competition they may carry when used by a dominant player. The concept of an ecosystem has been explicitly confirmed by our courts, and it also features in our newly adopted revised market definition notice that was just adopted 2 weeks ago. And the court underlined in the Android judgment that digital ecosystems means distinct but interconnecting markets requiring, I quote, multi-level or multi-directional examination. So you're talking of things that are necessarily substitute, they're actually usually not, and they're usually complementary goods. So maybe if 20 years ago we would have called that conglomeral theory of harm, but it's a bit more than conglomeral because the the competitive relationship is much more direct. In a merger context, the fact that markets are complementary and interconnected, so part of an ecosystem, is relevant. It's also relevant in antitrust, frankly. And that explains why we are increasingly putting the emphasis on what we call non-horizontal relationships, by lack of a better expression. Because in digital, but also in other markets like pharmaceuticals, these non-horizontal relationships are sometimes extremely important for the way that innovation takes place in these markets, and also how, frankly, innovation can be hampered by anti-competitive practices. So I would say that I would not say that the ecosystems theories of harm as such. The ecosystems is only the market context that we take into account. Let me take the example of the case we just prohibited, which is Booking e-Travel. So I suspect you know Booking. Booking is a platform for booking travels, hotels, etc. But they do not integrate the booking of flights. And e-Travel is probably the best the technological leader in flight booking in Europe. These two wanted to merge. It's interesting because it's not horizontal, it's not really vertical, so it's non-horizontal, really. And by the own internal documents of Booking, when they decided to make the acquisition, what they were expecting was that the acquisition and the integration of the two services would boost the market share of e-Travel, and would actually even boost the market share of Booking, which is currently representing between 65 and 70% of all online booking in Europe, by something between 3 and 5 percentage points. And you may wonder why. I mean, it's remarkable in my view that a non-horizontal operation leads to an addition of market shares. And the reason is explained in the own internal documents of Booking, and that's what they call the stickiness of the consumers. Once you have entered an ecosystem, you tend not to leave it. So if you can book your flight on the ecosystem in which you usually book your hotels, you will. You will not bother to go and shop in a number of other platforms. And if you enter through e-Travel to book your flight, you will very likely, even if you're not a Booking customer, become a Booking customer. Hence, the hiring of the market shares. So that is really interesting, because this type of mergers allow gatekeepers, so companies that have a market that commands the access of a number of other markets, to entrench their position on the core market. And that is the theory that is at the heart of this case. So I thought that would be interesting for you to be exposed to these considerations. So I'll stop there. Precisely a half hour, so that's good. We have 25 minutes because I need 5 minutes to join my car and go to my meeting with Mrs. Vestager for the questions, and I'm happy to take any question you may have.
Thank you very much, Olivier. Does anyone has any questions to raise? In the meantime, I have a question, and perhaps consider that the audience is mainly Latin American. What are if you could include some words on the recent trends on international cooperation? How do you see that, and in both in conduct or merger cases? Do you see any changes, or do you foresee some?
Okay. Well, first of all, we traditionally and for a very long time the Commission invests a lot in international cooperation, both in cases and actually also in capacity building for sister authorities that are smaller than we are. We benefited ourselves. I was at the beginning when we created merger control in Europe in the early 90s. I was one of these pioneers. And we had no experience. We knew nothing about merger control. And frankly, we were extremely happy that the US FTC sent 3 experienced people, which were for 1 year with us in order to help us take off. That was extremely helpful. And this is what explains how I see international cooperation. First, it's a way for authorities that have some experience in the field to help colleagues to gain more quickly the relevant experience in order to be more active. Now, in actual cases, what I see today, I think we are in an era of unprecedented cooperation. I mean, we probably have the best cooperation we ever had with the US. First of all, because there is a meeting of mind. I mean, as you know, for a long time, we were seen as the outliers in the EU, 2 interventionists. That's basically a story of the last 20 years. We were enforcing quite a bit more than our US colleagues. And of course, that has changed. That has started to change about the middle of the Trump administration, when they started to open some cases in digital. And there is a very clear change under the current administration. So that, of course, triggered an extent of cooperation that I think we hadn't seen since the mid-90s. So we have very intensive cooperation. We're like-minded in many fields. Of course, we have our differences in legal standards, and so that means we not necessarily have the latitude to do the same things. But certainly at the level of analysis, I see a high degree of meeting of minds. We have also developed a new type of cooperation, if I may say, with the UK post-Brexit. Because, of course, the UK was part of us. So a number of things the Commission was doing for the UK, like the big mergers, etc. So now they're doing it on their own, and that triggered the necessity, because they have exactly the same legal standards as we do. They still operate under the same text as when they were with us. That triggers, of course, a need of alignment, cooperation, also because the market structure is likely to be exactly the same. When the markets are European, they are usually European, including the UK. And therefore, it would be very inconvenient that on the basis of the same facts, we reach different conclusions. It's a bit less inconvenient with the US because there are many reasons why you may reach different conclusions. The legal standards are different, the market structures are different, the facts we consider may be different as well, to an extent or another. So that's the second thing. With the rest of the world, we have bilateral cooperation as well, but it's more seldom. It may be that we have a case that is reviewed at the same time in Australia or in Mexico, and for a moment we have a very intensive cooperation in that very case. But then for months we may have very little interactions as well. So much for the bilateral cooperation. But what is really important for me is multilateral cooperation, because this is really where we can go together through a collective learning curve, learn from each other, and build a kind of a common understanding of things and common way of thinking about competition issues. So that is why the ICN is so crucial. That is why the OECD is so crucial. That is why also regional cooperation organizations are extremely important. And we have made an extra effort recently in the Commission, because I have posted in Paris one of our colleagues in order to really focus on multilateral cooperation, so in particular OECD and ICN. And I think there is perfect complementarity between the two. OECD is more geared to, I mean, kind of conceptual reflections, which is very useful. And ICN is really about operational cooperation, enforcement issues, really something that's closer to the field.
Great. Thanks. Leo Peralta has a question. And Esteban Greco has also raised the hand. First, Leo Peralta sent a message first. No, Leo.
Hi, good morning. I've got a question about how does this Digital Markets Act is affecting the merger review procedures. I understand that one of the biggest impacts of this Digital Markets Act is related on how does the European Commission reviews mergers from digital companies. So I would like to know a little bit more about this impact. I understand that this Digital Markets Act enables the European Commission to review other kind of mergers in the lower of the threshold established by the regulation. So I would like to have a little bit more of detail on this impact. Thank you.
Well, thank you, Leo. That's a very interesting question, and it goes in many other dimensions than the ones you just mentioned. So let me be, I mean, a bit systematic in addressing it. The first way in which the two interact is that the Digital Market Act is an ex-ante regulation. So, you know, whenever you review a merger, what it is about basically is defining whether the merged entity will have the ability and incentive to do a number of things that would be likely detrimental to competition. So ability is fine, but when it comes to incentive, you cannot ignore the fact that there is a regulation that prohibits a behavior. So if your theory of harm is, oh, post-merger, this company will have an incentive not to say, prevent side loading of apps outside of their app store. That did not exist pre-merger or is strengthened. You need to see how the fact that the DMA exists and prohibits that impacts that likelihood. So you need to factor it in assessing how likely it is that this incentive will materialize. And that is completely a question of fact. This is a question we had to resolve recently in Amazon iRobot. You will never see the decision because Amazon decided to pull out a week before the decision, but it's something we focused quite a lot on it. And my view is that, it's a question of fact. If the behavior we're talking about is something that is very easy to detect by the victims and by the regulatory authorities, which is the case of sideloading. I mean, if Apple prevents sideloading, well, it is mandatory to allow it. The day they do it, I have 1,000 complaints 2 hours later on my desk. So the likelihood is they will not. So even if in a world without the DMA, they would have an incentive, in the DMA world, this incentive is actually jeopardized. And we need to factor that in our merger assessment and consider that they're likely not to do it. But conversely, we talk about tweaking the deep layers of the algorithms to self-favor your own products versus competing clients' products. That is very unlikely to be detected either by us or by anybody else. So then you should conclude that the DMA, although it prohibits it, is unlikely to affect the incentives if it's usually profit-making to do it, which was the case in Amazon iRobot, the reason why we were about to prohibit it. So that's the first way it interacts. So you have to factor in, as a fact, the existence of the DMA and its impact on the likelihood that the behavior you fear would materialize post-merger will actually materialize or not. The second aspect is the one you mentioned. And it's not that the DMA allows us to review mergers. The DMA is silent on this. The DMA only says one thing, is that gatekeepers have to inform the Commission about all of their operation, irrespective of any thresholds. This is the only thing that Article 14 DMA does. But under the merger regulation, we have 3 years ago, when we decided to take Illumina Grail, which, as you know, we ultimately prohibited, we decided to change our recommendation to member states in terms of use of Article 22. Article 22, to make a bit of history of the merger regulation, has been introduced in 1989 in the original merger regulation because some of our member states didn't have a merger regulation. And they were willing to be able, in case a national merger would impact negatively competition in that territory, to ask the Commission to conduct the investigation and take the decision on their behalf. And for that reason, of course, Article 22 by definition means that even if you, as a member states, do not have competence to review a merger, you may still give competence to the Commission to do it on an ad hoc basis. Now, for 30 years, we have discouraged the member states to do it below the national threshold of competence that were provided for in their national merger regulation. And the reason for this is that, well, first of all, they nearly all have a national merger reg, which was not the case at inception. And secondly, that before the digital age, you had very, very, very few possibilities that a merger that is below national threshold could possibly impact competition on such a scale that you would need the Commission to review it, and not the National Competition Authority. This has completely changed now. When Meta buys customer, it is below virtually all the thresholds of all national competition authorities, but still it impacts competition worldwide. When Google buys Fitbit, it's the same. Or where Illumina buy Grail, to take an example, in another field than digital. So the world has changed, and in the world of today, the target can have zero turnover, and still the merger can have a huge negative impact on competition on a very wide scale. So we changed our recommendation in 2020, and we told the member states, for these reasons, now we would like you to refer to us mergers even when you do not have national competence. And the first such case was Illumina Grail. It's not something that is going to be massive. We have seen only 2 cases after Illumina Grail, both in digital, actually. But we believe this is something that is important. And it is, of course, connected to Article 14 DMA, because we have the information about all these transactions, and we can therefore tell them, and they say, well, this one we really think we should review. So please ask us. So that's how it works. But we're talking about 1-2 operations a year.
Thank you.
Great. Since we're running out of time, we will take Esteban and Diego's questions together, and then you answer both, Olivier, if it is okay with you.
Fine.
Great.
Thank you, Olivier. Excellent and useful insights about developments. I don't want you to miss your next meeting, but I know you are going to talk in OECD Competition Open Day about consumer welfare standard in informed decisions. And this maybe is related with some discussion about broadening the goals of competition law enforcement and competition policy. And I want to ask you if you can say your opinion shortly about if this discussion has influenced this reviews of these regulations, mainly, for example, the guidelines for unilateral conducts.
Well, that's a very good question. Let me clarify what I think is the standard in Europe. Traditionally, the US have a very clear and narrowly defined standard of consumer welfare. That's not our case. And you have many views about what is the standard in the EU. My view is that the standard in the EU is what we protect is the function of markets in allocating our scarce resources in the best possible way. So allocative efficiencies for the economists in the world is, I think, the standard. And of course, when you do that in a normal world, it so happens that you maximize consumer welfare as well. So that's why consumer welfare is a good proxy to measure whether you're effective in protecting the allocation functions of market. But consumer welfare is not the standard in the EU. And actually, you can see that because unlike in the US, we do not have, for example, restitutions. So, and it's important because that explains that this is linked to many things. This is linked to the fact that we are not a unitary state. So one of the functions of our competition enforcement is also to make it that our internal market, although we have 27 sovereign, we have only one single market, is more than a free trade area, but is less than a single state. And this internal market is not fragmented and functions well. So that's why it explains why we have competition rules that are targeting states and not only companies, unlike everywhere else in the world. But that's why it explains why we do not have a strict consumer welfare standard. So it's really idiosyncratic to the EU. That gives us quite some flexibility. And if you look at our enforcement practice of the last 10 years, you see that have allowed us, without having to ask ourselves too many questions about what consumer welfare meant, to have a full set of cases that are focused on the protection of innovation as a process, in mergers, but also in entitlements. Because there is a question whether the protection of innovation belongs to the consumer welfare environment. In the narrow sense, probably not. But this is not a question we do have to ask ourselves in the EU because we do not have a strict consumer welfare standard. So that's the first consideration. I think it's quite important. That also allows us to take into account a number of positive externalities. So you may have seen that we have recently adopted our horizontal conduct guidelines, and we have dedicated quite a big part of them to environmental efficiencies. So, and again, you may think or not that it's part of a welfare, a consumer welfare standard. We don't have to ask ourselves the question, because it's certainly part of well-functioning of markets and the way they allocate those scarce resources. So, my view, it's also part of a consumer welfare standard if it's well defined, because the quality of the air you breathe, the cost of everything that comes with global warming, all this is something that should be avoided, including through competition policy means. So that led us to take a number of cases, like very interestingly, for example, in cartels. You may know our decision against German car makers because they had colluded in order to delay the rollout of innovation for cleaner technologies in the environmental field. That for us is completely part of our standard. And also, if you think about it in terms of cartel, you have two ways when you cartelize to maximize your profit. Either you maximize your prices by allocating customers or sharing territories or simply fixing prices, or you reduce your costs. And these days that innovation is increasingly defining of competition relationships, reducing your costs by jointly deciding to slow down the rollout of innovation so that nobody makes the first move towards the more innovative and more effective technology is quite a good way to catalyze. So we've also been doing this. But on the other side, what the horizontal guidelines foresee is the possibility to exempt, to make positive determination for agreements that have beneficial effects on, say, decarbonation, for example. And that triggers a number of very interesting considerations, like, because, you know, global warming is a global problem. And in a way, whether you decarbonate in China, in Europe, or in Latin America, doesn't matter. What matters is how less carbon do you put in the atmosphere globally. So that comes the question as to, you know, what is the harm if the agreement is anti-competitive? But can you apportionate the benefits to European consumers that are the victim of the practice? And how do you do that? And we have had a lot of discussions in Europe about the concept of full compensation. So should the European consumers be fully compensated, or is it sufficient that they are compensated to some extent? My view is that this is a very theoretical discussion that we practitioners shouldn't have. Because, you know, when you're making this balancing act between the negative consequences of an agreement, which is usually a highering of price, relatively short term, and that you can, in principle, measure it. And the benefits, which are usually a bit more diffuse, more foggy, you know, more complicated to measure it precisely, you're actually comparing apple and pears. And we've been doing that forever. So these environmental agreements are just a new variation of it. But nobody is able to tell you, oh, consumers are compensated 101%, or they're compensated only 99%. That is nonsense. So in the end of the day, this is about whether the authority, and further on the judges, think that the consumers are globally better off with the agreement when you balance out the anti-competitive effects and the efficiencies. So that's the way I see it. And I have to say, we're probably helped in the EU by the fact that we do not have a strict consumer standard, welfare standard. For unilateral conduct, it's a bit more complicated, obviously, because you do not have a balancing act. We cannot exempt abuses of dominant position. The only thing you have are objective justifications. And objective justification is arguably a narrower concept. So, but that is a discussion we're having in the run-up to the 102 guidelines with, and I'm sure we will have just as lively debate as we have had for the guidelines in Article 101.
Great. I think you have run out of time. So I think that you have time for Diego's question.
A small last one. So Diego,
Okay.
Go ahead.
Thank you very much for your time. I'm wondering, what do you expect from the companies in the time regarding the fact that TMA Act applies only to Europe market? Can some companies lose interest in the European market, or they just can't lose their participation there? And what do you expect from other authorities regarding this regulation?
I don't expect anything. I mean, we are making regulations for all jurisdictions. We are enforcing it in all jurisdictions, and we have no extraterritorial dreams of power. We're not expansionists. So now what you see is nobody, well, I mean, I think Meta decided not to roll out a service in the EU because of the DMA. Very good, no problem. A number of others, including Meta, actually decided conversely for a number of other features to make changes to their business model and to apply it in the entire world. And they did the same thing already for the GDPR in the past. And that is because there is a cost, of course, in fragmenting your world markets and operating different algorithms depending on the regions of the world. But that is a business decision. I'm completely agnostic with this. They do whatever they want, providing that in my jurisdiction, they comply with my standards. The second part of your question, in a way, is we have the DMA, the Brits have the DMU, the Australians have something that resembles the British system. The Americans are trying to do the same through their antitrust enforcement. Is it a problem? No. For me, it is a source of effectiveness, because the choice we made with the DMA was to have very narrowly defined obligations and prohibitions, so that it's very clear what you cannot do and what you have to do. The beneficial aspect of this is that, of course, it's clear, it's immediate, and we cure the problem we had with antitrust enforcement, which is we were always sanctioning the practice long after it has produced its detrimental effects, and these effects are irreversible. But the downside of it is that, of course, the narrower a prohibition is, the easier it is to do something else than what is prohibited, but reach exactly the same effect. So circumvent the obligation. So we have two answers to this. The first one is we have an anti-circumvention system inbuilt in the DMA. So that if you do something that is really close to what is prohibited, but not exactly this, but reaches the same effect, you're meant to infringe the DMA. However, but if you're smart, you will do something that's a bit more further away and still reaches a similar effect, and then we will have to revert to Article 102. And then that would probably be just as slow as it always be, so we will need 2 or 3 years. In which case, maybe the British system for this specific type of things will be more effective, while in other cases, because we're more precise, we will be more effective than them. So I think the heterogeneity of the systems is not a problem. It is a source of effectiveness. If we manage, for as long as we pursue the same goal, and for as long as we closely coordinate. Well, thanks a lot. I need to run.
Thank you very, very much, Olivier. It has been a pleasure. And to the rest of you, I look forward to seeing you next month. We have Herbert Hovenkamp speaking about the goals of antitrust and his views. So that will be in the 28th of March. Thank you very much. A pleasure.
Bye.
Bye.
Thank you. Thank you, Oliver. Thank you, Julian.
Thank you so much. Bye-bye.
Bye-bye.
Thank you.
Gracias. Muchas gracias.
Muchas gracias. Un gusto estar acá. Gracias.
No, de nada.